things in your pack. You'll see reading and understanding the title commitment and an actual copy of a title commitment. The title commitment has been changed to protect the guilty. The names have been changed. So I just quickly want to go over it. So when you guys should be getting title commitments from the title companies that are closing your transactions, you should be forwarding them on and probably discussing them with your seller and buyer, just to make sure that everybody is on the same page, because the title commitment reveals things that sometimes the sellers aren't even aware of. Sandy, do you have a little packet?
Yes.
Okay, bravo, thanks for coming. All right, so we're going to start with Schedule A of the title commitment. And when we're looking at that, what you want to do is the commitment date is always going to be the date that the public records are through at the time that the title search was made. We do an update, usually the day before closing, and then that brings us a little closer to date just to make sure that we have everything that's recorded of record included in our closing.
If you guys can follow along, the second page of this packet is the Schedule A. And you'll see there's a title commitment behind the first page, which is kind of the payroll context.
Okay. All right, great. So then the commitment date, I think everybody kind of understands that. It'll be updated at the closing table, and typically they'll update it the day of closing. Title commitments cover the gap. The gap is between the date of closing and the recording date. So when the final policy comes through, the date of that policy will actually be the recording date. That's on the instrument. And then we go down to proposed insured. That should be your buyer. You should make sure that the names are typed correctly. If it's in a trust, that they mention the trust, and all the verbiage is correct. It should match the contract. If it deviates from the contract, you might want to take a look at it, or there could be an addendum that's needed to correct the contract, or we need to correct the commitment. The lender is the next proposed insured. They'll worry about all their information. They get it to us, and along with the loan amount. You also want to verify that the purchase price is correct, that there's not any changes, that maybe an addendum came through that wasn't caught. Then we're going to go down to the fee simple, the estate, and the estate or interest in the property. Typically, you're going to see fee simple title. That's the way most property is held, in fee simple. Occasionally, you will see leasehold interest estates, which means there's an underlying lease that somebody has an interest in the property. And occasionally, you'll see equity interest, which means they just have an equitable interest, not necessarily a fee simple interest in the property. They're entitled to money. Really, that's what that means. So that's really it for the Schedule A, other than the legal description, which is on the next page. When you're reviewing the title commitment, you need to make sure that your legal descriptions matches the contract. Then again, at closing, you'll want to make sure it matches the deed, and you always want to match it to the survey. All three of those items should be the same there too. And that's it basically for the Schedule A. That's all that you really need to be concerned with on that. Title insurers, Terry, we're always more than happy to review any title commitment that you get, and we'll give you our opinion as to what should be deleted. If there's any issues, bring it up to us, email it to us, we'll take a peek at it and give you our opinion of it as well. So now we're going to go to B1. These are requirements that need to be cleared in order for us to issue title insurance. And these are requirements that are found of record. Keeping in mind, there could be some weird situation that isn't of record. Forgery, fraud, undisclosed errors. So there's all kinds of things in the back chain that aren't even disclosed that title insurance would cover, that maybe you just don't even think about could be a possibility. Incompetent signers is another thing that we see. Title companies our underwriters pay out huge amounts of claims every single year. Absolutely.
Guys, this Schedule B1 requirements is probably the most important thing for you guys to be looking at, to pay close attention as she's going through this. What this means is that if one of these requirements are not fulfilled, you will not close. So when you see on the other page, we're going to get to exceptions. Yeah, that certainly pay attention to this, but this right here is the key to your success or failure in trying to get this to close, and then being able to advise your buyer, hey, you may want to look at these things because there may be a time that you have to and things need to be taken care of. It may be an issue that takes multiple months to take care of, which may not help you with your closing date. So that's why when you get this title commitment, what you need to do is pay very close attention to this, with Schedule B1 requirements.
Okay, so typically what you're going to see are the standard requirements. On the top, we have to be able to identify the parties. We have to be able to identify the price. We have to disclose the premiums. And then we get documents prepared in order to convey the property. So really, we're going to start with number 5, which is the warranty deed. We all know from some of our monthly meetings that we should be using statutory warranty deeds. Special warranty deeds only if they're allowed in the contract, and you should beware if somebody wants to offer you a special warranty deed, because there's certain restrictions that go along with a special warranty deed. Banks will only issue special warranty deeds. So if you're buying a bank-owned property, the difference between the two, a warranty deed, the seller will defend the title all the way back until the end of time, the beginning of time. And special warranty deed, they will only warrant the title during their ownership. So they could potentially be big deals that way. But your title insurance, you have that. That should cover against any adverse issues. So you always want to make sure you're getting the proper deed. Terri, if you want to go ahead and speak to 18H of the contract.
What you'll find in 18H, and that's both the as-is and the FAR 5 with repairs contract, it identifies that the type of deed that should be conveyed is a statutory warranty deed. And it goes, or other deeds that this may implicate. And if you read the language, it specifically says under 18H, a statutory warranty deed, a trustee deed, or a guardian's deed. They can only give you that which they have, basically, unless you can go from a special warranty deed, which would be only, I'm only, when I purchased the property, say, and now I'm the current owner, I may have gotten it through a special warranty deed, but it doesn't mean they can't give you a general warranty deed to your buyer who's now purchasing from you. Because what that says is it says, hey, I am agreeing and I am indemnifying and I am saying that any type of liens that arose in a general warranty deed, as she said, from the point that basically I owned it and that I continue to own it all the way back in time, I'm going to say there were no liens that were unresolved. There's no issues, no clouds on title that have not been resolved. Special warranty deed instead, and we run across this, and Barbara can vouch for this, we had a very tricky seller whose attorney tried to pass off a general warranty deed that was in the requirements as a general warranty deed, and it only provided the buyer with a special warranty deed. Why? Because that attorney was representing the seller, and he knew that there was actually a lien that needed to be taken care of that was in the chain of title before the ownership of the seller. So the prior owner, who happened to be one of the contractors, who's now a member into the new owner. It's pretty convoluted, and I'll get into it if you want to ask me later. I'll kind of explain to you, but I will tell you this is what alerted me to understanding that you guys need to know the difference. There's a lot of flippers out there. Do not allow these flippers to somehow substitute or try to give off a special warranty deed just because they know the title agent and they talk them into it. So the trustee deed is if the trust holds the underlying property and that's being conveyed, then basically, long story short is that the only thing they can give is a trustee deed. Same thing as
May I just give a million kudos to Terri, because she caught all this, because I asked her to review things, and she rectified everything, including getting a lien taken off the brand new property that was put against my buyers. So thank you.
So the next one is the mortgage. We all know the lender prepares the mortgage. If your buyer's not getting a mortgage, then you might want to call the title company and say, why are you calling for a mortgage? Also, this is the point where you would see satisfactions of current mortgages. Your seller should pay close attention to that. If you take a listing and they say, oh, we own this property free and clear, and then the title commitment comes back and there's 2 mortgages on it, you might go, oh, wait a minute, let's see what happened here. Sometimes people don't think lines of credits are mortgages. They misunderstand that. Or it could be where a mortgage didn't get satisfied at record. Or sometimes the clerk will even misindex. That's another issue in the public records as well. When things get misindexed, you can't necessarily find them easily. Moving on to the next one is a termination of notice of commencement. I think we're all familiar with notice of commencements. It's very important. This is a huge step that we have to take when there is repairs that require the terminating of the notice of commencement. We have to get contractor affidavits from the general contractor listed on the notice of commencement. We have to terminate the notice of commencement. Title insurance, typically the termination of notice of commencement isn't effective for 30 days after recording. The title industry has allowed us to record it and close based on good faith from the contractor's affidavit. So we record both of them at the same time. The contractor's affidavit ensures that all the subs have been paid. So we rely on that. But a lender could come in for 30 days at the filing of that notice of commencement and file a lien. It would be covered under title insurance if that were to be the case. But we're able to rely on that. We feel like there's enough proven information to where that doesn't happen enough. So they don't make us terminate it 30 days prior to closing. Otherwise, it could delay a lot of closings. Sometimes you're doing these things at the last minute for a roof that has to go on the property, and the last thing you want to hear is, well, now we got to terminate the notice of commencement, wait 30 days, and then close. So the underwriters have allowed us.
One more thing, the notice or the termination of the notice of commencement needs to be recorded. One big clue that there's a big problem with your title agent is the fact that if you see in this, the requirements, if you see that there's a notice of commencement and you know they're supposed to be doing a termination of this notice of commencement recording, you should see a recording fee for that. And if you're not seeing a recording fee, which is one of the heads ups that we saw, then you know that they're not terminating that notice of commencement and there's going to be potential problems down the road.
So just things to kind of be aware of. The next one, that is an affidavit of continuous marriage. And you probably do see that a lot. In the world, we have to sign that we've been married continuously since we own the property. Some people do get divorced and remarried. And during that, and then divorced again. And then during that time, when you own it, when you're not married, judgments can attach versus when you're husband and wife, you're one entity. So that's why we have to sometimes make you sign or make your client sign continuous marriage affidavits that they've been continuously married throughout the ownership of the property. And typically that also pertains when you have a similar name, Smith, Jones. That means there's a judgment against somebody with a similar name, but only one name. When you own title as husband and wife and it's a primary, any judgment that would attach to that property has to be listed in both names, not just one name, or they don't attach to a primary. So that's why we get the continuous marriage, because if there's a break in that, then they could attach. The next one is, this particular gentleman's name was Smith. So there's all kinds of judgments against a J. Smith, a D. Smith, where the underwriter felt, oh, this could be close enough to them, so we just want them to confirm that it's not them. So we do, there's different ways based on the judgment. Sometimes they list the date of birth, sometimes they list the last 4 digits of the social, at previous addresses and things like that. So we can kind of discount them and not just rely on seller's information, although they're signing an affidavit, because sometimes people fib. That we've discovered. The next one is just for homeowners association. Make sure if you do have a homeowners association that it is being verified, collected, prorated, whatever needs to be done. You guys know if you're selling in a property that has a homeowners association, so you know how to disclose that and to make sure that it's collected properly, because you don't want your buyer to come back and say, hey, they haven't paid their dues for 6 months and there's been no lien filed. So the title company should be checking that. And typically there's a charge for them to check that item as well. And then the next one that you'll see on this is just proof that all municipal charges and assessments for water, sewer, and waste collections are paid. That's when we run an assessment and utility search. Those are the searches that we do. And that tells us whether everything's current and up to date. In our area, very rarely do we come across delinquent water bills. You just don't see it that much here, thankfully. But that's how we base whether or not we will hold for a final water bill or collect for a current bill due. And that is based on the information that we receive from the city or the county. If they're delinquent, we're gonna hold for that delinquent bill, and we're probably gonna hold for the final bill itself. If everything is current and up to date, then we're not gonna withhold anything. The seller will just pay their final bills if they receive that. And that's kind of the way that we base it. You don't insure water, so it's important that your buyer does have the water on in their name when they come to the closing table, because they would probably be told at that point if there was a delinquency. They are in the city of St. Pete, I know that. They will tell them that there is a delinquency that has to be taken care of. So it's so important to make sure your clients don't say, oh, we'll turn the utilities on after closing, because there could be important information that they need prior to closing for that. So that kind of goes through B1. And then we're on to B2, which is the exceptions. This is what your buyer will be taking the property subject to. And there's going to be a lot of deletions that are made at the time of closing. Number one, that is the gap language. That's what says that we will cover from the date of closing through the date of recording. Again, title insurance has provided us, as long as we have a bona fide purchaser, that we can cover that gap. Number two, if you have a survey, then that item will be deleted. If you don't have a survey, it will remain. With the caveat, if there's any encroachments listed on that survey, that encroaches into the rear easement, the driveway crosses over the front of the property line, those items will be itemized and subject to on the final title policy, but they'll be also disclosed in another form as well. Those are considered removable items. The driveway needs to cross the front of the property line in order to get to the street. Everybody does. The easement in the rear, if it's a removable item, it's not a big deal. Permanent is what's a big deal. No plumbing, no electric in easements. And then, of course, you want to make sure that your property is within your guidelines. And we'll go over the survey in just a few minutes. The next one is rights or claims of parties and possessions. That typically is deleted unless you have a tenant or leases on the property, and then it will be subject to those items. The next one is just liens, and that is deleted. Easements and claims of easements, again, deleted from the final policy. Number 6 remains. That's real estate taxes for typically the current year going forward that are not yet due and payable. Any taxes that are due in arrears obviously should be paid, and that would be listed as a requirement under title commitment. The next one is the water. That is not deleted off of an owner's policy. Typically, some attorneys will require that it is deleted. That is your water, saying that we don't insure water. But if you pay close attention to the last few words, none due and payable, you want to make sure that your title commitment reflects that. That means that the title company has done their check to make sure that everything is current and up to date. But this also allows for liens to be placed on the property after ownership. Seller doesn't pay the final bill. They have yet to file a lien, and we didn't get the water turned on, so we didn't know about it. So it does provide for that, and your buyer is taking it subject to that. That's why the water is so, so important. Usually it's not a big amount, but nobody wants to pay somebody else's bill, no matter what it is. The next one is just matters of plat. I think everybody's probably familiar with plats. That's what the developer creates when he creates the subdivision. So he lists the easements. If there's restrictions, he would draw all that on the plat. Those run with the property, there's no way to remove them. Covenants and restrictions. This particular property had restrictions on it. The OR books and pages are listed of those restrictions. Feel free to, if you're trying, we typically try to email all the exceptions so everybody can look at that when we send the title commitment out. But if your title company doesn't, or if you can't, if you didn't get them, feel free to call your title company and ask them to send you a copy, a complete copy of the documents that are on the exceptions. You're entitled to them. You should read them, or your client should read them anyway. Some of these look like very old OR books and pages, so some of that stuff is on microfiche, so it's a little hard to read, I will say that. But we can always provide copies of that. Condos is a little bit different. We typically don't get into the condo docs. Those are supposed to be provided by the seller to the buyer, but we have access to them. If we needed to pull them, we could. There. Riparian and littoral rights, this means the property's on the water. This particular property. We don't insure, the next one, we don't insure any part of the waterway. So we stop at the property line, we stop at the seawall. Anything beyond that is not insurable from a title company standpoint. Number 13, that typically pertains to lenders, those are the endorsements that our title insurer, our underwriter, our searcher feels that the lender should have on this property. Just for knowledge, the 5.1 is a PUD endorsement, plan unit development, so rules, regulations. And the Florida Form 9 ensures against any encroachments, overlaps, problems with the survey. And that's certified to the lender. Just gives them a little extra coverage. And the next thing that you see are the notes. And that tells you the tax information, that they're current and up to date. And it also lists the last couple, usually the 24-month chain of title comes in after that. So you can kind of see all that there. And that's basically it for me and the title commitment. Did anybody have any questions? Or it should be, I think all you guys are experienced. So what you got, Bob?
In section 8C, I think it talks about when the title commitment date is. It's 15 days prior to closing or 5 days, I believe, if it's cash. Are we?
I'll be going over that.
Oh.
We have different little things because she's going to do more of the contract.
Okay.
Yeah, part of it. So I think with that said, Terri, if you want to go ahead and continue with your little section there, and you will find it very informative.
Now, we just talked about what are considered exceptions, what are the requirements, and basically what is considered a title issue. And it becomes very important, now that you know what title issues are, to also know what are not title issues that a lot of people assume are title issues. The chief one of those issues would be code enforcement violations, notice of violations. One of the biggest issues is that you will see there are requirements in the contract that a title company make sure that there's no liens that arise under certain sections of Florida statute. Those sections do not include 162.091, which is the fines for a code enforcement violation, as well as 162.093, which is the lien that eventually arises from a fine from a code enforcement violation. That's where there's an issue, is because when you have a property that's subject to a code enforcement violation, a red tag, say, unpermitted work that was discovered, it takes time for that municipality to identify and to go in and decide what they're going to do about it, because they have to post, they have to notify the owner. Unfortunately, what we have seen over and over again, and this is why we're covering this, is people think that is a title issue and impacted by what Bob was going into is to the cure period for a title defect. It is not. You can be caught into a very bad situation if the local lien and municipalities have not been checked to determine whether or not there's any type of code violations and whether or not there's been notice of violations that will eventually lead to a lien, probably post transfer of the property. And that means the new owner buys the property with these code violations and potential liens. Understand the fines, according to Florida statutes, could be up to $250 a day for these unresolved code violations, and up to $500 a day for repeat violators. And the maximum would be $5,000 in fines for that particular issue, or $15,000 if it's something that cannot be repaired. Also note that the city is capable of foreclosing those liens, and that can put your new buyer in quite a pickle because they don't have any way of curing this once the transfer or that the property has been transferred. That's another issue that has come up recently, is that a new owner must always go get an architect or engineer to be able to pull an after the fact permit. So keep that in mind. Open permits, notices of violation, those things are not title issues. They must be discovered. They must be resolved during the inspection period. Exclamation point, exclamation point, exclamation point. If you're looking after your buyer's interests, please make sure you convey that. And if they're going to want to do a local lien search, many title companies are requiring an extra fee. Can be, how much is it for you guys to do a local lien search?
$185. And that's if we outsource it. City of St. Pete, we can go ahead and do that at the city.
We have-
that on every bill.
And we have put that in our buyer's disclosure. So if you guys are familiar with your internal buyer's disclosure, look at the very bottom. We identify that a lot of title companies do not tell you that you can get a local lien search. Yes, Dan?
So if a bank is selling a property that they admitted all over the place that they're loaded with liens, they have a different kind of warranty deed, so that really puts a huge pressure on the buyer, right?
That's correct, because what happens is basically in the prior chain of title, which would be the person who was foreclosed, they could have done a bunch of unpermitted work. And guess what? You are on the hook for that as purchasing, even though you're the next person in title, because all of that follows the land. Good point. Okay, so procedure. Now, what happens if you have a real issue with the title? Now that you know what to look for, I mean, would everyone agree that you kind of now have a better understanding when you're looking at commitment? Raise your hand if you have a better understanding. Okay. Now that we know that we all have a better understanding, now you need to know that in your contract, you have under section 18, you have a procedure that talks about how long and under what circumstances a title commitment must be provided to the buyer and what the buyer has to do if they want to file an objection. Okay, according to section 18, you'll see that at least 15 days of blank, or if you fill it in, or 5 days if it's a cash purchase, okay, prior to closing date to obtain a title commitment. If the title commitment is not provided within 5 days of closing, guess what? It's an automatic extension for the buyer to give the buyer the ability to object to the exceptions. So please keep that in mind because that's going to impact your closing date. So make sure that you have tickled or put a note or something as to when the title commitment must be provided to your buyer. Yes.
And this has come up, this came up early in my career, it came up with one of our agents where they had a defect or a problem with title. And the seller's just like, well, I'm just not gonna sell them the property. That can't happen. There's an automatic cure period that starts if there's a defect on the title. So just be aware of that. The seller can't just say, I'm not gonna sell it because they didn't meet the closing date. It's the seller's responsibility to provide a title that can convey to the buyer.
And that gets into the next thing is the buyers they have only 5 days to object. So what he's saying is he's right. Unless the buyer fails to object, that puts a lot of onus on you guys to make it's not. And I don't ever want you guys to pretend you're a lawyer and be reading them and giving them their legal rights and responsibilities. But there is something that's to be said about being a professional that identifies for your client, hey, this is how the procedure's supposed to be. And you read it from the contract and you show them in the contract. That's not giving legal advice, that's doing your job effectively, okay?
Is that 5 days or 5 business days?
That's a good, I think it's, I remember,
Depends on
it's
It
gotta
goes
be,
to time.
Yeah,
so
I'm
if
not
it-
going
if
back to the
that 5
time.
days, it's calendar days, but if it ends on a Saturday, Sunday, or the holiday, you're closed over the next week.
yeah, there's only 2 exceptions to that, and that's the effective date, and there's one more, I just wanna make sure that's not it. I'll get back with you and just make sure, because I don't memorize the contracts, I just go to the places that say it. So that's exactly what you guys need to be doing, okay? Is go to the contract, and then you look up the answer. All right. So you have buyers 5 days, okay, to put in writing. Understand, this isn't just something that they can call up and say, hey, what is this? I don't get this. Or you guys can't do this on their behalf. And that after that notice, then obviously the seller has 30 days to take reasonable, diligent efforts to remove defects. That is an onus and an obligation on a seller to engage in reasonable, diligent efforts. We all know what that means because of the whole loan approval thing, right? We all kind of know, hey, what is reasonable, diligent efforts? That is something that's a requirement. So if you're representing a seller and the seller's not doing anything about it and just wants to time things out and say, I just don't want to cure this, no. That you have an obligation underneath the contract to tell your seller you need to be taking reasonable, diligent efforts to clear this defect, if it truly is an intentional defect. Also understand that if there was no notice, then the buyer accepts it as is. So this is where you guys can get in some trouble. Now that you know what to look for, do yourself a favor, do RE/MAX a favor, and Metro a favor, and most importantly, do your buyers a favor to let them know, hey, we have a certain time period that's governed. We look through this. I can't give you legal advice, but this is what I say. Okay? Is there another question?
Just a comment on that, but title insurers or a good title company is gonna identify, hey, there's a problem. But we know not everyone's that great out there. If it's a law office that doesn't do a lot of closings or whatever, they're just gonna slip that thing in, exclude it, and move on. So we gotta be paying attention to what those exceptions on the title are, because if there's a big one, we don't wanna just let that go through. We wanna stop and say we object. This is a problem. So that's something that should be escalated to me or Terri if it needs to when we're looking at the title stuff.
Now, once it is cured, then there's a notice to buyer that says you have 10 days to close. So understand that there's bookends to this. Let's make sure that we govern getting a new closing date and effectively closing. If there is no seller cure available, they can't cure. Then after the expiration of that cure period, then the buyer may, within 5 days after the expiration, extend or request or demand, should I say, another 120 days to force the seller to cure. I've run into this multiple times where people say, well, hold on, they can't make me go ahead and cure this. Yes, they can. Okay? Yes, they can. So that covers what the procedures are. I've written them out for a cheat sheet list here. So when you have this, keep this piece of paper. It identifies kind of what it is that you need to do. And we try to do this so that you guys can have a quick reference. We're also going to put this on the hub at some level or some location so you guys can also have it handy available. All right. If there's no more questions, actually you're going to do surveys now, right?
Yes, go ahead and do surveys.
All right, we're going to move on to surveys unless there's other questions, and we'll just have those questions on the
Okay, there was just a little survey checklist, just a little one. We'll kind of just go over that real quickly. The thing is, when you are reviewing the survey, there's certain things you want to make sure that you look for. Does the survey have a signature and seal from a licensed Florida surveyor? You always want to make sure. Most surveys now are signed electronically, which is awesome. Typically at title insurers will send it to the buyer, just so they keep it on their desktop, put it in a folder on their computer, because every time they print it, it's an original. And we know when you need a survey, when you go to close, when you go to refinance, or when you go to pull a permit. So if you have it on your desktop, it's just really handy to get to. You also want to make sure that it is properly dated and certified by the surveyor. Are there any unusual notes, statements, or legend markers? So you want to make sure that you read all the information that's kind of provided, or familiarize yourself with where the surveyor notes are kept. So at least you can read that to see any remarks that they may have. Does the legal description match the title commitment? As we discussed earlier, that's one of the 3 steps that you need to check: that legal description, title commitment, deed, and survey. All of the 3 of those, so 3 of those should match verbatim. Does the survey show any encroachments into easements or adjoining property? You want to make sure that you're aware of that as well. Do any improvements from adjoining land encroach onto the insured land? So your neighbors, are your neighbors encroaching into your property? And does the survey show legal access? Most of Pinellas County, we don't have that kind of a problem, but you could have some rural land that there could be a parcel behind a parcel. Just because you see a dirt road doesn't mean that that's legal access. So you always want to make sure that there is legal access to the property. So I just gave a few examples that we can look at real quickly, just so you can see what we look at from a title company standpoint. A, we would consider that pretty close to perfect. Everything's within the guidelines. The fence kind of sets off the property line. The concrete walks cross over the front of the property line, and then the drive crosses over a little bit in the back. If you look over in the 3rd box down on the right, that's where our surveyor has made his notes, and that's Exhibit A that you're going to look at. So you can see what he lists as possible encroachments as well. So those are some things that you would always want to pay attention to, are the surveyor's notes. You can always call a surveyor if you have questions. They'll take your phone calls. They'll be more than happy to share their expertise with you. Now scheduled our Exhibit B. This one is a little bit more convoluted. This particular seller bought this property cash. When you visually look at the property, you think the well is within your property lines because of the way that the fences are set, the concrete set, all of that is off the property line. So this particular seller doesn't really have access to their own well because it's on somebody
Yeah,
else's.
the well is right here at the bottom, in the corner, it says well, you see that?
Here you go.
Okay,
Bottom left-hand corner?
Yeah, and that is
The
also,
right-hand
yeah, the darker line is the property line.
Actually, it's the right hand.
Yeah. Yeah.
So it's north.
So you can see, but visually, if you looked at that property from the street, because of the way that the fences are situated, you would think this is my property. But unfortunately, what a survey revealed on this is the well is outside of the property line, the concrete's outside of the property line, and the fence is on the property line. What had to happen here? The seller had to relocate the well
Right.
in this property. And now there's actually a situation with that because they feel like they've moved the well too close to the septic tank. So they actually created another little issue when they tried to correct this issue. So even when it's cash, you might want to look at a survey because what you're actually visually seeing may not be correct. So people think they own more than what they own, and they'll even move the survey flags. Your neighbors will. No, they're not quite right. I own 2 more feet. I know I do, but really they don't. And then Exhibit C. This is just an example of where pool water is in the rear easement. Pool decking isn't a problem, pool water is. So what the seller had to do in this case, you can see it right in the rear of the property, just go a little bit over, you can see the decking is definitely in the easement, but you can also see pool water. And again, that's a problem when it's water. So what the seller did in this case is they got a minor easement permit. Some people think of them as variances. This is not a vacation of easement. There are 2 different types of things. This allows the owner and any new owner to have the pool in the easement, but with the caveat, if they need to get there, it's at the new owner's expense to fix that so they can get into that. A vacation of easement would mean that whoever has the rights to that easement is vacating that portion of the easement. Typically, they will never vacate the entire easement, but they could give you 6 inches, a foot, if they don't feel like it's going to bother them in any way. In this particular case, it was simply a variance, the right to use. Yes.
Do you know what influences whether they give a variance versus a vacation?
It's what you asked for.
What is that for vacation?
Most people do, but you also got to use common sense too. Are there power lines above there? What's going on underneath there? What's the likelihood of my approval for a vacation? If you think it's slim, why go through all that process when you're going to have to re-go through that process again when you might just want a variance? But at least you're kind of semi-clearing the way for someone else to at least be able to enjoy their property. So, and in this case, it's so little that I am sure that the utility company would be able to work around whatever is there. And the city and the county are so good at working around whatever you have put in those easements. And they typically will try to put it back the way that they found it. They'll place sod, they'll just do everything because they don't want to be on Bay News 9. And they're saying, the city gave me a tour of my property. So those are just some examples. If you get a survey from another title company or a seller, again, email it to us. We'll be more than happy to look at it for you and give you our opinion of that survey or items that we might see is wrong. And just one more thing. A lot of times nowadays, people are using a seller's existing survey. You might think that's the cheap way to go and a savings for your buyer. And it can be. $275. Who doesn't want $275? But you have to make sure that there's been no changes to that survey at all. And they say, oh, well, we removed an above ground pool. We kind of added a fence and a deck, but we can see that everything's within the guidelines. You really should get a new survey just to make sure that the fence stayed on the line where it did, just so we don't have to disclose that. So if you're looking at a survey that was not even certified to your seller, maybe certified to the seller before, and you say, well, God, this one shows that there's a shed and there is no shed anymore back there, you probably want to get a new survey. It's worth the $275 to get a new survey certified to you, and that's just my personal opinion on it. Because again, people will fit, and they'll say there has been no changes. And then we aerial view it, and we can see that there's changes. So, because they just don't think that they're important enough changes. So, kind of wraps up the survey for me.
All right, now the business entities portion that I've been promising for a year. Hey, we're finally here. We finally have it, guys. And this is for those people who run into these situations in which it's not just an individual owner or a married couple who are selling property or purchasing property. Under these circumstances, if it's a corporation that's purchasing property, it might be a commercial investment, but if it is a situation in which a corporation is selling corporate-owned property or a trust is selling trustee property, there are certain requirements to make the documents legal. When I say documents, there's two things I want you guys to be thinking about. A, your listing agreement. This is the most important thing to get you paid. This is the thing that I want, that I hold dear to you guys, to make sure that it's done correctly, because if it's not done correctly, then whenever you come to me and they're trying to get out of the contract, I have to tell you it's unenforceable against the entity that you put here because you didn't get the right person, you didn't have the right signature, they didn't sign in the right capacity. That's a huge, huge deal for the rest of the entire transaction. So if you're representing a seller and the seller is not a typical individual person or a couple, then you're in a position in which you need to come back to this cheat sheet, and that's why we have it, okay? Find out what it is that the title company is going to be requiring of them, and maybe you need to also look at, if you can, and a lot of places people aren't going to give it to you just from the asking at the listing, but be aware that you really need to get this to make sure. And when some of these documents I'm going to tell you that you need gets handed over to the title company, you need to check that with the title company. Just kind of keep that in the back of your mind to make sure everything adds up. If not, you're going to have to modify your listing agreement as well as modifying the underlying contract. So let's look at the type of business entities and capacities in which they can go ahead and take or sell property. Corporations is the first, and that's pretty common out there. Everyone sees Inc., Co., Corp. Behind a name. Just know that I'm begging you guys to go, if it's a Florida corporation, go to sunbiz.org, okay? Pull that up. Do your due diligence on your seller. Make sure you know who the president or vice president is of that company. It will say that. Make sure that you know that entity is still in business. If it's an administratively dissolved entity, it will say that. An administratively dissolved entity cannot convey property. And what will happen is the title company will not be able to sell that property. They're going to have to go through a big rigmarole in order to actually reinstate that corporation to be able to sell that underlying property. So that's going to take you time, and sometimes you can't reinstate it, depending on the circumstances of it being administratively dissolved. The other issue is the fact that you need to verify that the correct name of the company is listed on your listing agreement. So there's case law out there that says if a corporation is close, Scrivener's error, we might be able to get by with it. Just don't put us in that situation. Take the time to double check where the commas are, and it will say so on Sunbiz. If you have any questions as to how to look it up, call me, I'll walk you through it, okay? Just make sure you do it. You have a signature block for a corporation here. This is how it's supposed to be. One of the things that I did, since I'm not an agent, is I went over to Bob this morning and said, Bob, can you put in fields in your listing agreement? Can you put in fields, you're using app files in your sales contract? He said, most certainly you can. It just takes effort. So please make sure you do it. follow this type of format and understand that a president should be the one who's signing it. There can be other people, but you may need a corporate resolution in order to make sure that you know. Now understand there's something called articles of incorporation, which those are filed with the state if it's a Florida corporation, and or bylaws, and those may or may not, usually not filed with the state. Those bylaws will identify who it has the ability to convey that underlying property. It may also be in the article. So that's what a title company will look at and require. If it's an out-of-state entity, they actually have to, the title company has to actually request a certificate of good standing in order to make sure that the corporation is in existence from that underlying state. Let's go down to limited liability companies, LLCs. LLCs are really a different type of hybrid over here. LLCs are members, okay? They're no longer shareholders. And the member's interest is all that can be levied upon. So because of that, it's very, very important that you know who the members are and whether or not it is a member-managed LLC or a manager-managed LLC. About 3 years ago, there was a new, maybe 2 years ago, state of Florida created a different type of ownership for LLCs that was no longer manager-managed and said that any member then can be, in other words, all the members manage it. There's not just one manager. So I put in here basically what you would need. If you know if it's member managed, then any one member, unless otherwise stated, and where would you find who has the right? You find it in the operating agreement. This is who the operating agreement is, says, like the bylaws, this is who is it, or who are members. This member is appointed to be able to convey land. Yes, we can convey land. No, we can't. So operating agreements are LLCs, and you'll see that over here. If it is a member-managed one, please understand that you do need to probably have the operating agreement to see, because technically any one of them can do this, but you don't know who has the ability to convey, and that's usually spelled out in the operating agreement. Again, LLCs are registered with the Division of Corporations, SunBiz, so you can go right on SunBiz and you can pull up exactly who are the, if it's a management member, and they also have the articles, and the articles identify as well many times who, if it's manager or member managed, okay? So you do have the ability to check that. If you have any additional questions when you're running into this, you call us and we'll make sure we walk you through it. Did you have a question as well?
Yeah, what do I do if one LLC is owned by another one? How deep do I have to go?
Then what you do is you contact one of us, because I was going to say that's going to be the last thing, because it becomes even more important when you have a limited partnership, and we'll get to that in a second, because you can have a general partner who is the entity that needs to sign for a limited partner, and that could, and the limited partner could be a corporation. Now you're doing layers and layers of research. So call us. That's the answer. Okay. That gets us to partnership. I'm sorry. And the signature block for an LLP is also written right in through here. Okay. There's also an affidavit that could be required. It's like, we call it the certificate of incumbency. If you're trying to go ahead and encumber, you want to make sure that, by the way, the LLC was formed before you had this transfer of ownership. Because if you can see here, I pointed out, deed prior to LLC formation is void for lack of grantee. So if they're in the process of getting this LLC together and they don't have it all done, because many times attorneys have to put together the operating agreement and attorneys take time, then guess what? You cannot have your closing, okay? A good title company will not allow it. That title company might, and guess what? It's a void transaction, okay? Partnerships, just like I said, there's general and there's limited. A general partnership is not registered in SunBiz, so you have to ask for a partnership agreement. I would suggest this. Partnerships, general partnerships are rarely used in the state of Florida. Make sure you get the general partnership agreement. I can't say that enough at a listing, because let me tell you, there's many, many times that you will find general partners, since it's an old style way of holding ever since LLCs became really popular, or limited partnerships became popular, you're going to have all kinds of problems, chances are, if you have not looked at the general partnership agreement. So get it at the listing time period. And the other thing is that there is a statute in the state of Florida that says, in order to protect these general partners, I mean, they realize that there's all kinds of issues with general partnership, one going rogue, okay, whenever they can't. And so what they say is you can actually record a statement of authority in public records, and that the title company will bring up, or anyone is on constructive notice that they're not allowed to convey any of the interest for the general partnership. So if there is something in public records, just so you know, if you see it, it's an agenda. They're telling you it's a partnership. One of the things you can look up on your own is you go to Pinellas Clerk, any type of whatever county it is, their official records, you look underneath the name of that general partnership, and that should tell you if there is a statement of authority that limits the scope and power of the other general partner to be able to convey real property or any assets of the underlying partnership. Again, you have, I only put the limited partnership signature. You can only imagine general partner is going to be the same thing for general partner, but the reason why I put the limited partnership signature is because only a general partner can sign on behalf of a limited partner. So if you see LP or LLP, be aware that this is a different type, and you have to be able to look at that and make sure you know what type of entity you're dealing with and get the right signature. Also understand that many times you're going to need approvals, or what they call consents, and that's something that the title company will go ahead and get. There is also a certificate of limited partnership that can be filed as well. Attorney in fact, we just had a most recent situation with a wonderful power of attorney. You better get a copy of that power of attorney. You better make sure they have an original of that power of attorney. Do not do anything as far as conveying property without verifying that that power of attorney is in their possession and is an original. And you also have to look at that power of attorney. It should say the scope within it as to whether it's allowed to convey real property. If it doesn't say that, you need to inquire further. You cannot just assume, just because someone has a power of attorney or attorney in fact, that they are operating with the power and authority of the grantor to be able to convey real property or purchase real property. The signature block, just take quick attention. I have John Smith this is John Smith Jr. That's the person who has the power of attorney or is attorney in fact. Understand that this has to be written like this. It is important. The person who conveys the power, whose authority that you're signing the documents on behalf, has to be written on top, okay? And then the person who actually is the signer has to be written at the bottom, identifying his position, which is attorney in fact. Trusts. That is a very tricky thing in the state of Florida. No trusts are registered. What can be registered in public records is a certificate of trust. I've seen it recorded. It's usually recorded with real property as to if you have a trustee's deed in the first instance. Usually the certificate of trust is recorded. What a certificate of trust is it's an outline of the underlying trust. Understand that this trust could have been amended since such time as a certificate of trust that you were relying upon. I always ask if there's any way you can get the underlying trust document and all amendments, please do. The reason why it's so important is the certificate of trust should identify the exact name of the trust. You'll see in here I have UAD. It's under agreement dated. Many times and I just had a huge lawsuit, still pending, over a foreclosure because they actually didn't have the right, there was actually an amendment that no one knew about. And they tried to foreclose on this amendment that didn't exist. How did we know about the amendment? Based on the trust date as amended, and then they put in the date that didn't exist. So be very, very careful that you follow it says the name as stated in the trust, and you follow every single letter exactly how it's named. Because otherwise, that trust is not on the hook for anything. And you need to have the trustee, not any of the beneficiaries, okay? None of the beneficiaries have a right to convey property, only the trustee. And that certificate of trust identifies, as well as the underlying trust document, identifies who is the actual trustee. If you have any questions, the other thing is just, you don't have to be experts, call us, okay? You have a trust, call me up or call up, one of the brokers and say, I got a trust, can you just verify that I have this listing, that I put it in the right name? Really, really important. And if not, then you need to get it amended when you do get the underlying trust agreement. Yes, sir.
Should we have most of this information when we go to the listing? Like if it is a trust?
Yes. Yeah, and when you go to the listing, you're gonna be requesting that. Again, what you have two options. You can either have it there or request it before you get there. I mean, I don't know, it depends if it's the first time you met with them or a second, or whether they've already agreed to give you the listing. But get it, and if you are writing the contract and you don't have the exact name, ask for it and then amend it. Okay, and we'll help you out with amending. The only last issues, which we started not quite on time, so we're not going to finish quite on time, but this is going to be the last thing. These are capacity issues. They're very simple. I think that Robin has already identified the fact that a husband and wife, it basically links can unattach if they own the property, tenants by entireties. I have in here that basically the reason why is because of homestead interest. If it is a homestead, if this is where these not investment property, but their underlying homestead, then basically you're going to need, I don't care if the husband's the only one on the title, the wife is the only one on the title, you will need a homestead waiver. So bottom line is both of them have to be on the contract. And that's something that I have run into. We have specific language. If you need that language to put on number 20, if you look up and you find that the deed for when you're giving a buyer an offer, that the deed has in there, Joe Schmo or Joe Smith, a married man, but doesn't have the rest of the information, I have something that that we can put in number 20 to identify exactly this is what we need it to read, that they're going to you're going to have to know that wife or that spouse who is not on the, and you're going to have to ask them, are you married? If they say they are married or they're not married, are you fully divorced, okay? Make sure of those things, because if you try to convey and they are married, but she wasn't on there, she's going to have to be at the closing table, at least file or sign an affidavit that identifies the fact that she's willing to get conveyor interest. Because in the state of Florida, homestead isn't just the right to be able to decrease your taxes, okay? It isn't the exemption that you get to help you during taxes. Instead, it is a constitutional right. So, and I kind of give a little brief synopsis as to how basically things, and you'll see it under probate, follow through if the spouse dies. And so that's also under probate. I'll get to your question in 1 second. Minors, just so you know, a minor, anyone under the age of 18 can never, ever, 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 ever contract. Okay, they're able, it is void ab initio. It means it's not a voidable contract, it just doesn't even have any effect. Okay, and they have to have a guardian. We'll go through that with you. Probate is very clear that I've written down kind of how you devise, but I'll leave that up to you. Whenever you run into a probate situation, just read this and you should have all those answers. And we have kind of brought it in within an hour. Are there any questions that we can field?
Just real quick, on the husband and wife thing, does that only include the homesteaded property? Like if a husband owns an investment property, does the wife need to sign? What does that look like?
We have not an investment, we will not have them join on the deed, but we do put in the deed that it's not the homestead property of the grantor. So they are signing that and they are attesting to that. If we see that it was ever their homestead, we'd want the spouse to join in. And we have them sign the deed.
We have a question from Gary Smith. What is the waiver clause that circumvents the death of a seller?
Okay, that's going to go into, there's spillover trust, there's all kinds of ways that you can devise property in the state of Florida. There's a key case that says if you want to be a curmudgeon, you can be a curmudgeon. You can actually undermine the elective share of a spouse. You can do all kinds of things. I'm not a trust and guardian attorney. I never have been, but I will say Fisher and Sauls, where I came from, has a very robust probate and trust area. So my answer to that would be go to a probate and estate trust attorney, because there are different forms of circumvention that you have to, again, if they say I have a certain type, you're going to need to go to at least have some idea of how to deal with that, and I'm not going to be able to give you that type of assistance. Yes.
One other thing, from Remat's standpoint, if you have the listings, there's also have the title insurance, when you have a fire that's 25 in the trust. In the past, we've always said we wanted the page that says the name of the trust and who, the signature page that shows who's consigned, and the title, just those 3 pages. Now we really want the full trust, because some people are kind of skeptical about, gee, I don't want to expose everything.
You raise a great question, because, I mean, again, state of Florida gives confidentiality to these trusts, and as a result, you're right, you can just request those pages. The certificate of trust, most attorneys will draft that with the underlying trust, and as long as it has not been amended, so if you ask if it's been amended, then get those provisions that were amended, and usually it's just a 1-pager, 2-pager of what's been amended, so they don't have a problem giving you the amendment, and then you can rely on the certificate of trust. But I can tell you, if you want to be thorough, ask for the full trust, but you are right. And that's why I say that's probably the trickiest, because a lot of trustees they guard that jealously, and they do not want anyone to know.
There's a lot of personal information there. Sure. But those pages would suffice in addition to the notary page.
Correct. Well, guys, thank you. I hope, listen, the last question we have, if there is anything that we've gone over that you want a more in-depth class on, we would like to hear that from you, okay? Just go ahead and email either one of us, both of us, we don't care. Just so you know, my past lives, I was also a commercial title agent. That's the reason why I understand title, but again, Robin and I work seamlessly behind the scenes to try to give you guys the best service in title, and if there's any issues, try to resolve those. So again, thank you very much for your time. I can't tell you how much I appreciate it, and hopefully you guys go out and sell and do well. I have validations. If anybody needs their card being validated, I have validations from both Sundial and Morgan Stanley. Just come see me. Yes.
I've got a fantastic $5,000 lot listing up in Lakeland. Scary neighborhood. I just put it on and all that. I've got to get is there a special listing agreement for land? I saw you had, it's been a while ago, Linda Gold. Yeah, she's a great lady. Yeah. She had all kinds of wonderful things to say about that. Yeah, she really is. I used to have mass land.